Hello, everybody, and welcome to Something to Talk About Live. My name is Jean Marie Navetta. My pronouns are she and her, or ella if you use Spanish, and I'm the Director of Learning and Inclusion at pflagnation.al. Every single week, we get together to talk about something related to LGBTQ equality and inclusion, and this week is no exception. So for those of you who have been joining us every single week faithfully or have seen before episodes, you'll usually see my colleague Liz Owen introduce me. Liz is a bit under the weather, so you have me the whole time, but here's the big takeaway on that. I am totally unsupervised in this very new year, so really anything can happen now. So we're going to have some fun today, even though we're taking on a pretty heavy topic. So today we're going to be talking about the courts, and in this case, primarily the Supreme Court. The article that we shared with you is available at straightforequality.org/discussion series. It was printed in Them, and the title of it was "The Supreme Court's Latest LGBTQ plus rights case is a chilling test of religious freedom." So make sure that you check out the article. It's pretty fascinating. It gives you a lot of things to think about. And, you know, when we think about the courts and when we think about the judiciary, sometimes it can be great. I can see case names to you like Obergefell or Lawrence or Roe. Sometimes it can be kind of terrible. Dobbs, Masterpiece, Cake Shop, Burwell versus Hobby Lobby, or maybe Dobbs. And if you're not sure what those cases refer to, those are the cases that brought you things like marriage equality recognition. It struck down the criminalization of consensual same-sex relationships. It literally legalized gay. That's where that happened. It gave us the right to an abortion. Some of the other cases also gave us things like corporations are people too. Discrimination's okay if it meshes with your religion, and the end of your right to getting an abortion. The court shapes our everyday lives, whether we are paying attention to it or not. Their decisions can be the difference between dignity or even criminalization of who we are. That's why it's important, and that's why we're talking about it today. Now, I am not a lawyer. I definitely do not play one on TV, and I can assure you nobody is ever going to mix me up with an actual attorney. So I definitely need some help for today's conversation. And for that, I am going to welcome our guest to the show for this week, Tobias Barrington Wolff, who is the Jefferson Barnes Fordham Professor of Law at the University of Pennsylvania, Carey School of Law.
Hey, Jean Marie, how are you?
I'm doing great. How are you, Tobias?
I'm great. Thank you so much for having me on the program today.
I am so incredibly excited to have you here. First, I've been following your work for such a long time, and you always just have such great insight, and it's just an honor to have you with us on the program. So for people who have not met you before, could you tell people a little bit about who you are and the work, broadly speaking, that you do?
Sure. So my full-time job is, as you said, I'm a law professor at the University of Pennsylvania, which is a wonderful, wonderful place to make a career. I'm very lucky to be there. And I've also done a fair amount of work as a civil rights lawyer, most of it as a pro bono attorney doing either appellate work. I've done more appellate work, but also some work from, starting cases from the very beginning. Most of it on LGBT rights issues. I've done a lot of work on marriage equality. I've done a lot of work on the equal service of gay, lesbian, and bisexual people in the military. I write and teach about the First Amendment, and the relationship between the First Amendment and equality claims is something that I've done a lot of work on, which is part of why I think you wanted me to chat with you today. And I had the great privilege and opportunity in 2007, 2008 to serve as the chief advisor to the Obama campaign on LGBT law and policy, and spent 17 months traveling around the country, speaking on behalf of the campaign and working with then Senator Obama on these issues, and then worked never in the White House or the administration, but as a kind of trusted outside advisor to the Obama administration for pretty much the whole time they were in power. And it was an extraordinary opportunity. And so I've gotten to see these issues from a whole lot of different vantage points.
And I appreciate that, because I think that is part of what we need here. I think that the issues that we're looking at, and we're going to be talking about that 303 creative case, they are complicated. And I think that sometimes we do need to take these different perspectives to understand what's going on. So I definitely want to talk about the concept of religious liberty, and in this case, how it plays up against First Amendment and free speech rights. But before we get too far into it, I want to talk a little bit about that concept of religious liberty and freedom. Because for many people, the first time that they ever really heard about this in any kind of formal way was around probably the Religious Freedom Restoration Act, when that became law. But over the past few years, that concept has been coming up a lot more often. And I think especially in the context of LGBTQ legal issues. So could you talk a little bit about how the concept of religious freedom that we're dealing with today differs from what was maybe originally established in RFRA? So for example, the evolution that has happened because of things like Hobby Lobby and some of those other cases.
Sure. So let me start with three sort of basic concepts, which I think are useful in defining what we mean by religious liberty. So one is the ability of churches, religious practitioners, not to be interfered with in the, if you will, the kind of core conduct of their religious practice, right? So to use a couple of obvious examples, the Catholic Church doesn't ordain women as priests. And, priests are employees, they get paid, they have jobs. And we have laws that say you can't discriminate based on sex in employment. But those laws can't and don't apply to ministers and religious practitioners, because that would be a very direct and core intrusion into the way that a religion defines its practice and defines its doctrines, right? And so there's a number of examples of that kind of what I would think of as the most clear core of religious freedom. A second idea is people who believe that their religious obligations or their religious belief require them to engage in certain kinds of conduct, right, that is illegal or that is prohibited by certain types of laws. The term of art that often gets used here is laws of general applicability, right? And one of the types of claims, which is really the one that's being most frequently litigated these days, is that a law that applies to everybody and is usually not problematic, a particular religious tradition, religious adherence says you can't apply that law to me because my religious belief says that, for example, I shouldn't provide certain goods and services to same-sex couples in the marketplace, or I shouldn't rent my facilities to certain kinds of people, right? And you might think of that as a special exemption type of argument about religious liberty. Then a third issue is you might think of as just plain discrimination, right? If the state targets somebody because of their religious belief or targets somebody because of their religious identity, then that's discrimination, right? That presents a problem of unequal treatment based on religion or burdening somebody because of their religion. And in the most sort of clear and obvious cases, it's very well established that you can't do that. We have laws against private anti-religious discrimination. We have constitutional provisions against governmental anti-religious discrimination. An issue that has been coming up recently and was the subject, it turned out, of a Supreme Court case that I think we'll talk about a little called the Masterpiece Cake Shop case, was, in closer, more debatable circumstances, where will we say that the state is engaged in anti-religious bias, and when might that have an impact on the way that cases get decided? And so those are kind of the three biggest, I think, examples of so-called religious freedom in religious freedom claims. So the Federal Religious Freedom Restoration Act, the statute that you mentioned, is about the second of those categories. It's about when a law of general applicability the argument is that it's burdening somebody's religious belief or religious practice. So for example, imagine that you're a church and you want to expand the physical plant of your church, right? You want to put a wing onto the building, whatever. And there are zoning laws that say you can't do that. Well, normally everybody has to abide by zoning laws, but can that church say, well, if you apply those zoning laws to us, it's going to really burden our ability to conduct our congregational work because we're not going to be able to expand our membership, or we're not going to be able to engage in the following religious practices. That's one possible example of what a RFRA claim might look like. right? A law of general applicability that a church or religious denomination says, that law may be fine in general, but it's going to substantially burden our religious practice if you apply it to us. And for a set of constitutional reasons that I can describe if you're interested, they're a little arcane. RFRA only applies to federal laws. It doesn't apply to state and local laws. And so when the Federal Religious Freedom Restoration Act is on the table, it is essentially serving as a carve out to other federal laws. Many states have enacted their own version of RFRAs.
Yes.
And they operate a little differently sometimes, but they're the same basic principle. And so the question of how this plays out in state and local law winds up being a state-by-state issue in many circumstances. But the federal RFRA plays a big role in federal law.
And it seems that a lot of the place that we are seeing these debates happening now, especially at the state level, specifically do have to deal with LGBTQ people, LGBTQ cases, and we knew the doc was coming up.
Spark is usually much more patient than this, but he's been a little bit impatient today. This is Spark. So P-Flag World, this is Spark. He is my beloved companion and my best buddy, and he is the greatest little guy in the world. And he has many opinions about many things, including religious freedom. So we may hear from him today.
Maybe we're going to have Spark and maybe my cat on as separate guests on a different day.
Totally.
I think we've got something there. So it seems like a lot of this stuff is happening. We're seeing it at the state level, but we are seeing some of these cases bubble up to the Supreme Court. So, while many people have heard about the 303 creative case, which was just heard, a lot of people associated that. And you mentioned the Masterpiece Cake Shop cake, in which a business owner actually declined creating a wedding cake for a same-sex couple because he argued it would violate his religious beliefs. Mm-hmm. Could you explain how these two cases are different? Because there is a significant difference in the cases, although there are some questions about if it's a legitimate argument or if we're sort of stretching to find other ways to apply law.
Sure, I'd be happy to. And I should just start by saying that I have some personal involvement in this set of cases as a lawyer. I submitted a brief to the Supreme Court in the 303 creative case. And I was lead counsel in the first of these cases, which was called Elaine Photography versus Willick, which was a case involving a wedding photography company in New Mexico that refused to do business with my client, a woman named Vanessa Willick, because she and her partner were both women. So this line of cases, there's one issue to get clear on from the very beginning, which is that it is these cases all involve people, litigants, business owners, who have religious objections to serving same-sex couples in matters relating to weddings and celebrations of weddings, right? But what has wound up being the claim that each of them is asserting is a speech clause claim, not a religion clause claim. At least that's been the primary focus of the lawsuit. The Masterpiece Cake Shop case and the 303 creative case both wound up involving the same type of claim. I have to, pardon me as we speak, there's a little bit of an adjustment that Spark is going to require. Hey, Spark, do you need to go outside, buddy? Come here. Oh, there you go.
This is how we know that everything is live.
This is real life. So both of these cases involved businesses where, as did the wedding photography case in Elaine Photography versus Willick, where the goods and services that these businesses provide have some kind of artistic or creative dimension to them, right? These are people, photographers, bakers who decorate cakes and cupcakes, website designers who design, templates and such for websites. That, the whole point of their business, the reason that they're getting paid is that they have artistic skill, they have creative skill. And the way that they have decided to monetize that talent is by setting up a business that operates in the public marketplace and that says, we're going to advertise, we're going to either have a physical store or we're going to have a virtual store, and we invite customers in to do business with us. Well, when you set up a business that way, there are certain rules that apply, right? You have to abide by health and safety rules, you have to abide by zoning rules, and you have to abide by anti-discrimination laws. And an increasing number of states and municipalities have laws that make discrimination against gay, lesbian, bisexual, and transgender people illegal in the commercial marketplace. And when these businesses started turning away same-sex couples and saying, in my case to Vanessa Willick and her partner, we're not going to photograph your commitment ceremony. In the Masterpiece Cake Shop case, we're not going to bake a cake for your ceremony. And in the case of 303 Creative, and we can talk about this, it's an unusual case. The woman who owns this website design company, she hasn't ever actually offered the service of designing websites for weddings, which is what she wants to start doing. This is a kind of theoretical lawsuit in which she says, I want to start offering this service. She's already got a website design company all set up. I want to start offering this service, but if I do, I know that Colorado is going to make me work with gay couples, and I don't want to work with gay couples when it comes to this particular service. So please, federal courts, give me the right to, ahead of time, know that I'm not going to have to work with gay couples. And the argument under the speech clause of the First Amendment in these cases has been that if the goods and services that we, the business owners, are offering are artistic or creative in nature, then if you tell us we can't turn away couples that we don't want to do business with, then you're effectively making us create art for somebody that we don't want to create for.
Right.
And we have a First Amendment right not to be compelled to create art. Now, stated in the abstract, that sounds like a very powerful principle, right? There is, in fact, an important line of cases that I've written about and I care a lot about that say you cannot compel people to create artwork. You cannot compel people to speak in ways that they would rather not speak. But the issue here is not that state law is demanding that somebody create artwork. State law is saying, if you set up a business in the public marketplace, whatever it is, we don't care what you do. Here are the rules that everybody has to abide by. And one of those rules is that you can't turn customers away based on, among other things, sexual orientation. And so the debate in these cases is about how to think about that situation under these First Amendment and free speech claims. Now, in the Masterpiece Cake Shop case, it looked like the Supreme Court was going to decide that issue, right?
Right.
And then this very unusual and unexpected thing happened, which is that the court wound up focusing on a feature of the record in the Colorado proceedings that happened before the Supreme Court, in which one of the state commissioners, one of the state human rights commissioners, had made some critical comments, sort of from not the bench, but from her desk, saying, it's really unfortunate that you're using these religious arguments to justify discrimination, and there's a history here, and some really ugly people have done similar things in different settings, and it's an unfortunate parallel, that kind of thing.
Right.
And the Supreme Court wound up saying, well, that constituted the manifestation of a biased anti-religious attitude, a hostility towards the religious beliefs of the business owner. And so they wound up deciding the case as one of those third category of cases that I mentioned, a discrimination case.
Right.
Which I had very mixed feelings about, because on the one hand, it seemed like, lots and lots of tribunals and administrative agencies and judges make lots and lots of comments about litigants who appear before them that exhibit disapproval or even bias or hostility based upon things like their class, their race, their religion, whatever the case may be. And I'm sympathetic to the idea that we should be policing that, right? This was such a departure from any type of willingness to take a hard look at that kind of biased attitude that the Supreme Court has ever exhibited, that it really seemed a little bit like, as some commentators have put it, religious belief was being given most favored nation status when it comes to
yeah.
So that's kind of the big set of issues around the commercial marketplace. That's sort of where they have landed right now. The constitutional claims are mostly free speech claims. And then there's also now this Masterpiece Cake Shop decision, which says you can kind of scrutinize the record and the statements made by commissioners and judges And if it looks like anything untoward is going on, then you may actually have a religious discrimination claim there as well.
Again, I mentioned this in the beginning, not an attorney, but in some ways, what you're describing to me sounds as though it is people looking for a way to justify their individual behavior in this case, to justify discriminatory behavior. Because if a religious claim isn't working, then we're going to jump to free speech. And my question is, where does this sort of end? Is this kind of dishonest reasoning that they're doing, or is there really a legitimate claim here?
Well, I think there's a couple things to say about that. So a lot of these lawsuits, most of them have been advanced by an advocacy organization called the Alliance Defending Freedom.
Yes.
And there's no question that they have been looking for cases and looking for litigants and so forth. And there's nothing inherently wrong with that, to be clear. Like civil rights organizations do that.
Right.
I think it would be unfair to say that the First Amendment claims here, the free speech claims, are somehow made up or, without any substance to them. There are very smart people of a variety of different belief systems who, take these claims very seriously, and some of them think that they're right. I think the claims are quite wrong. And I've been litigating these cases and making that argument for some years now. And the implications of the court recognizing a claim like this are quite broad because, a very large, the litigation papers of the lawyers for 303 Creative, right near the beginning when they're explaining why the First Amendment is at issue in this case, they say, this product that the owner of 303 Creative wants to offer, it involves carefully selected images and symbols and words. Well, if every commercial product or service that involves selecting images and words suddenly gives you a First Amendment claim that says you can discriminate and turn away anybody that you want, the marketplace is going to get turned upside down. And lots of what would ordinarily be just normal commercial disputes and business discrimination claims are going to suddenly get turned into constitutional claims. And that's going to be, I think, both an incorrect interpretation of the First Amendment if it happens, and also just chaotic.
Agree. And I know that I'm getting a little bit on wobbly ground here, but I'm going to ask the question. These two cases that we've talked about have been very specific. They have been about LGBTQ people and LGBTQ rights. Do you think the court would be listening to these arguments in the same way if perhaps somebody said, I adhere to a religion in which I believe that one race is superior to the other. As such, I don't feel comfortable as an artist being forced to produce a website celebrating Martin Luther King Day.
Right.
Would we be looking at the case the same way? Or are we looking at another case of where we are still looking at LGBTQ individuals with a slightly different light?
It's a very important question. And there have been any number of signals that the Supreme Court might very well draw a distinction between race discrimination and anti-LGBT discrimination and issue a decision that would license discrimination against queer and trans people in the marketplace, but wouldn't apply to race discrimination. So as one example, the Hobby Lobby versus Burwell case, which a lot of people probably know, Hobby Lobby was a case involving the Federal Religious Freedom Restoration Act, that statute that you mentioned. And it involved, of course, the mandate under the Affordable Care Act that businesses offer insurance coverage that includes contraceptive coverage, right? Mm-hmm. Now, this was a provision in the Affordable Care Act that was about sex and gender discrimination, right? The point of it was that services and coverage that is particularly important to cisgendered women is often getting systematically disfavored or denied by businesses in ways that constitute, at the very least, the creation of inequality based on sex. And so the Affordable Care Act was attempting to enforce a principle of sex and gender equality. And the Supreme Court found that RFRA gave businesses that had religious owners, which is what Hobby Lobby is, the right to an exemption to that requirement. In the process of issuing that decision, one of the things that the Supreme Court said was, of course, if this were a case about race discrimination, it would be really clear that eliminating race discrimination is a compelling state interest. And the only way that you can do that is with a law that makes every act of discrimination illegal, right? And so they kind of gratuitously said, what we're saying here would not apply to a case involving race discrimination. And by pretty strong implication, right, they said, insofar as people think that this contraceptive mandate is about sex and gender discrimination, that principle doesn't apply here, even though it would apply in the case of race discrimination. That's a fact about the Hobby Lobby case that doesn't get a lot of attention. And so I would not be surprised if the court does wind up ruling in favor of this website design company. I would not be surprised if they say, this would be a different case if we were talking about race discrimination. And Alliance Defending Freedom, when in litigating these cases, they did this in my case as well, in Elaine Photography. They go way out of their way to say race is different, race discrimination is different, without carefully explaining why. They just say, of course, this wouldn't apply in that setting.
Yeah. I'm looking at my time, and I see that we have about 4 minutes left, and I have at least 22 more questions for you, which is kind of a problem. So I'm going to have to grovel and beg you to come back and talk to me again.
Of course.
But there's one more thing that I just want to ask as we're going out, because we've really focused on this one case in particular and implications from earlier stuff. But 303 Creative is certainly not the only case that we're looking at. After the Dobbs decision, Justice Thomas made some remarks that caused to say a little bit of panic in our community, and many communities would be an understatement, asking the court to potentially reconsider cases like Lawrence and some of those due process cases. As you look towards the court in the upcoming year, do you think we have reason to be deeply concerned about some of these suggestions that he's making? And do you see any of these cases likely to get reconsidered anytime soon?
Well, I'm deeply concerned, and I would not be surprised at all if a state like Texas, for example, were to generate a challenge to Obergefell and have, for example, I could imagine state officials issuing an authoritative opinion that says, in light of the Dobbs decision, which overruled Casey versus Planned Parenthood, which was one of the real underpinnings of both Lawrence versus Texas and the Obergefell decision, we believe that Obergefell is no longer good law, and start instructing their local officials to cease issuing marriage licenses to same-sex couples. To be clear, I'm not aware that that's in the works right now, but it would not surprise me. Now, many of your watchers probably know that Congress just enacted this statute called the Respect for Marriage Act. Now, I'll do this very quickly. The Respect for Marriage Act is a very important piece of legislation. It is very far from a solution to this problem. The Respect for Marriage Act does three basic things. First, it makes it very clear that for federal law purposes, marriages of same-sex couples will be recognized so long as they're valid in the state where they were performed.
Right.
And that's a very big deal. And that finally gets rid of the Defense of Marriage Act off the statute books. Second, it says in the state-to-state context for so-called full faith and credit purposes, states are not allowed to deny recognition to a valid marriage because it's between a same-sex couple, or for that matter, an interracial couple. Now, the next time I come back, I can have a longer conversation with you about what that means. Those protections are not quite as robust as they might sound, but they're important. Right. The third thing, now both of those things have no immediate effect, because for now, Obergefell is still good law, right? So those two very important steps in the statute are anticipating the possibility that the Supreme Court might overrule some of these important decisions. The third thing that the statute does takes effect right away. And this gets back to the original topic of our discussion. It enacts some limited but important specialized religious exemptions. And it says that for religiously affiliated organizations, churches, but also just things that don't qualify as churches, but that are religiously organized groups, non-commercial, right? Not businesses, but all kinds of organizations that have a religious theme to them. they get now federal statutory protection against ever making any of their services or facilities available for a marriage of any kind if they disapprove of it. And so, as of today, and those go into effect right away, covered religious organizations can say, we rent out our meeting hall, for example, for marriages, but not for gay couples and not for Hindu couples and not for Native American couples, because we have belief systems about that.
Yeah.
And that is in effect right away. So there is now a specialized religious exemption, not for businesses, but for religious organizations when it comes to goods and services that relate to marriage.
It's a lot. It's a lot. And I think so much of this feels like it is being challenged and sometimes changing really quickly. And I think it's going to be a rough few years in front of us at this point.
It is. Let me offer just one quick word as a last word on that score. It is a tough time. And, my day job, my full-time job is that I teach brilliant law students and work with these amazing young adults who are the next generation of leaders at least in the field of law. And they are looking not just for, teaching, but also for some guidance and some inspiration about how to move forward at a very difficult time. And as much as we are in the middle of a tough fight, there has been a major shift in the level of support, I think, in the general population on many, not all, but many queer and trans issues.
Yes.
And to be perfectly honest, the work of PFLAG has played a central role in moving that kind of general level of community support. I have been a huge admirer of PFLAG for a very long time. And I think that the way forward is to continue both recognizing the serious challenges, but also recognizing that we have the wind of history at our backs, and to believe that and to act that way, even when we encounter really, really tough setbacks like the Dobbs decision. We still have the wind of history at our backs, and we have to keep thinking that way.
You know what? That is a perfect way to wrap up this conversation, Tobias, but I am holding you to this. I'm going to be asking you to come back because I think there is so much more that we need to talk about. And thank you for explaining these things. I feel like I'm light years ahead of where I started. I so appreciate you. Thank you for the lovely comments about PFLAG. And thank you so much for being with us here today.
It's my pleasure. And I would love to come back. So just let me know when you'd like to have me. And Spark will be here and ready to offer his opinion.
Spark is a requirement. He is absolutely required. Thank you, Tobias. We'll see you soon.
We'll see you soon. Bye-bye.
Bye. Well, everybody, see, Liz left me unsupervised and I went over time, but it was totally worth it. That was an incredible conversation. We're going to continue that one because I'm looking at people's comments and it looks like people want to talk about this. Thank you for joining us today. Just as a reminder, we are still continuing our Read with Love program. So if you want to lead with love, the place you can actually start is by reading with love. So check out pflag.org/readwithlove. I'm going to really encourage everybody to join us again next week. We have a fantastic show for you. Another one. PFLAG is kicking off its 50th anniversary year, and we have some major goodies in store, some exciting things that you're actually going to be able to see, and some fantastic guests coming on. So please come back next week on Thursday. Finally, if you need any support before then, you can find us at pflag.org and pflag.org/find to locate your nearest chapter. My name is Jean Marie Nevada. I will be back with you next week on our next episode of Something to Talk About Live. Have a good week, everybody. And as we wrap up the same way every single week, please remember to run fast, laugh hard, and most of all, please be kind. We'll see you next week.